Hey guys, today we are going to talk about the requirements for a valid will. Now, the only requirement for a will to be valid is that it is signed in the presence of two witnesses at the same time, both present. Now, there is no prescribed format for a will. There's no standard will or anything. Anybody can draft a will. There are homemade wills, there are internet template wills. In fact, there are will drafting companies where the wills are not even drafted by lawyers. And there are even insurance agents who draft wills for their clients. In fact, there was this Australian case where a man was crushed by a tractor, okay, and during his dying moments, he wrote on the tractor door, he was crushed by a wheel, and there was dust on the tractor, so he wrote, "All to wife," and then two of the people present signed as witnesses, and they actually brought the tractor door to the probate court for probate. So yeah, there is no prescribed format for wills. But I must say that for homemade wills, template wills, DIY wills, or wills drafted by will writing companies, or basically not at law firms, there is a higher chance that the court will request for an affidavit of due execution. Essentially, the court is wary, is not sure that the will was actually, the testator actually understood the contents of the will, or that it was signed at the same time. So the court will want one of the witnesses to swear or affirm an affidavit saying that he witnessed the testator signing the will in the presence of two witnesses, and that he understood the contents of the will. Now, the affidavit of execution will incur more costs because the lawyer has to draft it and all that. It usually costs about $1,000 extra. Section 6.2 of the Wills Act states that every will shall be signed at the foot or end of the will by the testator, or by some other person in his presence and by his direction. The signature shall be made or acknowledged by the testator as the signature to his will or codicil in the presence of two or more witnesses present at the same time, and those witnesses shall subscribe the will in the presence of the testator. But no form of attestation shall be necessary. Now, although the Wills Act says that there's no standard form of attestation. Attestation clause simply means, it simply states that it's two people witness the testator signing. But in practice, there are different types of attestation clauses, including attestation clauses where the will has been explained to the testator in a different language other than English, or where a thumbprint is used. If the testator uses a thumbprint, you have to include an attestation clause for thumbprints. Otherwise, there's a high chance that they will ask for an affidavit of due execution. Some people are concerned about where their signature should be on the will. Section 6, subsection 3 of the Wills Act provides that every will shall, as far as the position of the signature of the testator, be deemed to be valid if the signature is placed at or after, following, under, beside, or opposite to the end of the will, where it is apparent on the face of the will that the testator intended to give effect to the will by his signature to the writing signed as his will. So section 6, subsection 3 of the Wills Act goes on to state that the will not be affected if the signature does not follow or is not immediately after the foot or end of the will. So let's say the last clause of the will is here and the signature is here, okay? It doesn't affect it. It doesn't have to be exactly here. Or B, a blank space intervenes between the concluding word of the will and the signature, also the same similar thing. Or the signature was placed among the the words of the testimonium clause or the clause of attestation or follow or is under the names of one or more of the names of the subscribing witnesses. So this is the will. This is the last page of the will. The signatures of the two witnesses are here. Okay. If the testator sign below, beside, or wherever, it doesn't affect the will. Also, if the signature of the testator on the will is on a side or page or other portion of the papers containing the will where there is no clause or paragraph or disposing part of the will written above the signature, it doesn't affect. For example, page 5 of the will contain all the clauses. Page 6, okay, can only contain the attestation clause and the signature of the testator and the two witnesses. So that it doesn't, just because the signature is on a different page from the last sentence, does not affect the validity. Even though section 6 subsection 3 of the Wills Act states that it doesn't matter where the signature is located on the will, section 6 subsection 4 states that no signature shall be operative to give effect, okay, which is underneath or which follows it, nor shall it give effect to any disposition or direction inserted after the signature is made. So this, let's say this is page 5 of the will, okay, and the signature is here, okay, the signature is here, and there is some more clauses here at the bottom of the signature. These clauses shall have no effect because it is below the signature here. So thanks for watching this video on the requirements for the validity of a will and where the signatures are to be located.